Now, once you've decided you want to implement an arbitration agreement, and given that their class action waivers are enforceable, that's a huge advantage, and most employers want to implement arbitration agreements based solely on those grounds. You want to ensure that the arbitration agreement is enforceable to begin with. It has to be drafted in a way that the court will enforce by taking specific measures to ensure it will stand up to legal scrutiny when challenged by plaintiffs. The agreement should be legible and a standalone document, double-spaced, and prominently advise employees that they are giving up certain rights. Now, these are sort of, you would think that they are sort of obvious things to note, but it's very important that when you have an arbitration agreement, it's very prominent, it's legible, it's double-spaced, and things are highlighted or bold to the extent that they need to be. We do not recommend that you include an arbitration agreement in your employee handbook. You want the agreement to be enforceable, so it should be signed by both the employee and the employer to demonstrate that both sides mutually consented to the agreement. The employee handbook and its acknowledgement form typically state that the handbook does not create a contract for employment. So that's, one reason why you don't want to include the agreement in the employment handbook. So if you insert an mandatory arbitration agreement language in the handbook, it may also contradict your at-will employment statements in the handbook while opening the door to challenge the enforceability of the agreement itself. Similarly, employers generally do not want their handbooks to create a contractual right on the part of the employees, and should therefore avoid to bind an employee through a policy in the handbook. Another benefit of using a standalone arbitration agreement is that the arbitration agreement has to be entered into a public record to enforce the agreement. So this is where an employee challenges the enforceability of the arbitration agreement, and we're still in court. It's a public forum, and generally the arbitration agreement itself is an exhibit and entered into exhibit and as an evidence. And if you have it in your handbook, you don't want the entire handbook to be part of the record. And so that's why we significantly and always advise our clients that the arbitration agreement should be a standalone document. The next is, if the arbitration agreement is in English and a significant, or at least 20% of your population, or even if you are presenting it to an employee who may not be able to understand the arbitration agreement, consider translating the agreement into the language that they speak or understand. Next, you want the arbitration agreement to be signed. So electronic signatures are a good way of making sure that the arbitration agreements are signed. And you want to prove that the employee has signed the agreement. So while electronic signatures are acceptable, employers must review how the electronic signatures are recorded and ensure that this can be documented in a manner that will be upheld in a court when enforcing the arbitration agreement. So a lot of challenges that we're seeing now to arbitration agreements, number one, especially if they're electronically signed, we often have plaintiffs claiming that it's not their signature, they never signed it electronically. So that's where we need to understand and have somebody from the employer, the representative who's there and can very well explain the procedure that the employer has implemented to have these documents electronically signed. And whether it's, the employee creates their own ID and a password that only the employee and the employee is aware of. It's a unique ID and password. No one else has access to it. A link is sent to the employees. They click on the link, and then that's how they review and sign the documents. So everything that's in the background, sort of in the electronic discovery phase, all of this information will be handy, and we need to be able to obtain that when it becomes necessary to enforce the arbitration agreements. And we're seeing a lot of challenges to electronic signatures, and we're having our clients, by declaration, exactly go through what the process is and why that this electronic signature in fact belongs to the plaintiff. We've even seen courts having evidentiary hearings now because there's an electronic signature and they can't decide whether, based on the declarations itself, they can't decide whether they should believe the employer's witness who's saying that this is in fact the plaintiff's electronic signature versus whether the plaintiff themselves, electronically executed the agreement. Now, when you're having electronic signatures to the agreement, it's even more important if you have somebody who doesn't speak English, that you have procedures in place to show that even though an individual wasn't speaking Spanish or wasn't savvy in speaking English, it was in fact them who, clicked on the link that was sent to them and signed the arbitration agreement. And you want to include the Spanish version for them to sign in the package that they're reviewing. You want to give the employees an opportunity to read the agreement and be able to ask questions before they sign it. So oftentimes, one of the disadvantages we have with the electronic signatures where an employee is given the entire new hire packet, for example, and they're just log on and they're just going through and just clicking for their signatures. Oftentimes we'll see the timestamps for the signatures are literally, within seconds. And this especially becomes problematic if an employee is claiming that they don't speak Spanish. Well, they can say that, they were just sitting there with the employer at the time they were hired. They just went through and were told to just sign these documents without even an opportunity to ask any questions. So those are things that employers should keep in mind, especially when you have, whether it's electronic or hard copy signatures. You want to always make sure that when questioned, you can defend that the employee did in fact have an opportunity to review and ask questions before signing the agreement. Employers should always give a copy of the agreement to the employees. Typically, we like to include the language in our agreements that we draft, that the employees are free to take the agreement and have a lawyer review if they wish. We also include some language about the opt-out time that they have even after they sign the agreement. But actually, I think we have kind of moved away from that because that is not necessarily required anymore. But that if you have that opt-out language, it's beneficial. And make sure you always give the employee a signed copy of the arbitration agreement. Now, everything that I just discussed, I think comes down to training your supervisors in HR about the agreements, about implementing these agreements and making sure that they follow up to ensure that all parties have signed the arbitration agreement. There are times when we have arbitration agreements that are challenged because they have a signature line for the employee and a signature line for the employer's representative. However, that signature is perhaps missing. And, there's an argument that the employer never signed it. And if the employer, if the arbitration agreement did not call for the employer's signature, if it was material to the arbitration agreement, then why is there a signature line that is blank? It should have never even had a signature line for the employer. But so in those circumstances, it's important to ensure if the arbitration agreement is to be valid, make sure all parties involved have signed the agreement. You want to implement a system to track who has signed and who has not signed the arbitration agreement. Now, this is especially important when we are facing, let's say, a class action lawsuit. Because of the waiver, we want to be able to track easily and be able to get those numbers and those arbitration agreements, be able to gather them. Who are the employees that are potentially part of the class that actually signed an arbitration agreement with the waiver, and those that may not have signed it, including anyone that may have opted out of the agreement after they signed it. Next, processing, storage, and retrieval. So again, implementing a procedure to securely store signed arbitration agreements. This can be done manually or through an electronic system, but it needs to be audited routinely to ensure that the agreements are stored in a usable format, are backed up, and that appropriate people have access to the saved documents. We are also running into problems actually where I've had 2 occasions where the client cannot find arbitration agreements that were signed, or we can't determine whether these plaintiffs actually signed the arbitration agreements because the employer can't even find, part of their file. And it's not, and these are not employees that worked for the client a long time ago. These are actually recent happenings. And this is a client that actually implements arbitration agreement. Majority of their employees have signed the agreement, but for some reason, we're not able to find some arbitration agreements filed by at least 3 plaintiffs. That's where storing these agreements and these documents in a proper manner is very, very important. And also this becomes important when we have to produce these arbitration agreements in discovery. So being able to access it quickly and easily is a good practice to have. And also, if you are rolling out an arbitration agreement, a disclosure of a pending class action and representative claim has to be included in the arbitration agreement. So if you have pending class actions or PAGA representative claims, and you have employees that are already working and you are thinking about implementing arbitration agreements, those disclosures must be made in the arbitration agreement. Another key thing to remember is once you are in arbitration, it's very important to pay the arbitration fees very timely. So there's case law now that requires employers to ensure that they pay these fees, which can be significant, in a very timely and quick manner. And if these fees are not paid immediately in a timely manner, plaintiff's attorneys can actually file a motion and take the case out of arbitration and compel the employer to litigate it in court. So that's why it's very important to make sure that you pay the fees timely. And finally, if you have arbitration agreements, make sure that you have regular legal review of those agreements by your employment counsel, since arbitration provisions in employment are always being challenged. Different provisions within an arbitration agreement is always being challenged, and there is always legal developments that are coming down. So you want to make sure that at least once a year, your arbitration agreement should be reviewed by your legal counsel to ensure that it is enforceable.